Straight ahead on Law and Crime Daily.
As to the fifth count of the information Gage Grosskreutz, we the jury find the defendant Kyle H. Rittenhouse not guilty.
Defendant Kyle Rittenhouse is found not guilty on all charges. We are live in Kenosha with a reaction to the verdict. And the death of Ahmaud Arbery trial.
With that understanding, we rest.
All of the evidence that will be presented in this case has been presented.
Closing arguments loom in the racially charged case. Plus, a not guilty plea for a former Trump advisor. What criminal contempt of Congress charges mean for Steve Bannon. And later, a look ahead at the federal trial of GHISLAINE Maxwell, the socialite accused of facilitating Jeffrey Epstein and Brian Buckmeyer, along with co-host Terry Austin. It was the verdict heard across the country. As accused Kenosha shooter Kyle Rittenhouse is found not guilty on all counts. Anjanette Levy was in the courtroom as the verdict was read. She joins us now live outside the courthouse. And Anjanette, what can you tell us about the first moments after Rittenhouse heard the jury found him not guilty?
Well, Brian, it was incredibly tense inside that courtroom. Kyle Rittenhouse began to cry, as did his mother and other family members, as those 5 not guilty verdicts were read. Also, Rittenhouse collapsed as the clerk read that final not guilty verdict.
The first count of the information, Joseph Rosenbaum. We, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the second count of the information, Richard McGinnis, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the third count of the information, unknown male, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fourth count of the information, Anthony Huber, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fifth count of the information, Gage Grosskreutz, we, the jury, find the defendant Kyle H. Rittenhouse not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read? Would you wish the jury polled? No. Okay. Okay, folks, your job is done.
Now, after those verdicts were read, we spoke with Kyle Rittenhouse's lead defense attorney, Mark Richards. He talked about what it was like to hear all of those not guilty verdicts and what Kyle Rittenhouse said to him afterwards.
He thanked me. He was relieved. I didn't see Kyle's reaction until I got back to my office and they played it on television. You know, he's sitting to my left. I knew that he went down, but I didn't see it. And he almost passed out. There's no way, two ways about it. Corey and Natalie had to grab him and put him back in his seat. And, you know, he knew going into that room that he was either going to prison probably for the rest of his life or walking out a free man. I wouldn't want to be in that position. He thanked me. And we said we'd get together and talk about it after we've had some time to reflect and settle down. He wanted to get out of here because of security issues and things like that, and that's what happened.
Now, the family members of the 2 men shot and killed by Kyle Rittenhouse, Anthony Huber and Joseph Rosenbaum, they were sitting right behind me, and they held hands and cried quietly as those not guilty verdicts were read. Meanwhile, outside of the courthouse here, we heard from people on both sides of this case, people supporting Kyle Rittenhouse, and we also heard from those who supported a conviction in this case. One of those people was Jacob Blake's uncle, Justin Blake, and Jacob Blake, of course, is the man who was shot by Kenosha police in August of 2020, which sparked that unrest where Kyle Rittenhouse shot the 3 men. And some of the other people we spoke with say they feel this is a dark day.
They didn't charge the officer that shot my nephew 7 times in the back. So in the back of our mind, we knew you're in a city where things can go way wrong. And they did. They should have arrested this young man when he hit the illegal firearm. So the mayor, the police chief, the sheriffs, and the people, whoever was running the military that night, has blood on their hands.
I think that this is one of the darkest days in American history. This isn't just about Kenosha or Wisconsin. We just legalized vigilantism. Vigilantism is sport killing.
Now, as I mentioned, we also spoke with supporters of Kyle Rittenhouse. One man actually drove to Wisconsin from Omaha, Nebraska to show his support. You came here to support Kyle Rittenhouse?
Yeah, well, actually, I came here to support justice. That's the specific reason I'm here, and I knew that he was on the side of justice. From watching the trial, from all the information that I was able to gather throughout the plethora of news channels, watching the trial, I just believed that justice would be served, and exactly what happened.
Now, after a brief shoving match out here on the courthouse steps, things have been largely peaceful. Meanwhile, the Kenosha County District Attorney's Office, led by Michael Gravely, released a statement saying, "We respect the jury verdict, and the privilege of self-defense remains a contentious issue in our current times." The DA's office is asking for the public to accept these verdicts peacefully and not to resort to violence. Brian?
Thanks, Anjanette. Joining us today is defense attorney Kesia Early and Terry Austin. Kesia, reactions to the verdict, and how do you think we got here?
We got here for two separate reasons. I would say that a part of the verdict was reached because the jury obviously had a choice. Did they believe Kyle Rittenhouse, or do they believe that the victims were actually victims? And I believe that we live in my opinion, two separate Americas, because the facts were clear, the evidence was clear. However, the jury decided to acquit Mr. Rittenhouse on all the charges. We do have to respect the jury's decision, but I respectfully disagree with that verdict.
Now, Terry, an acquittal can come from a prosecution losing a case, defense winning it, or just the facts of the case. What do you think it was here?
No question, Brian. Binger lost this case. He overcharged and he underprepared. He should have focused on those lesser included charges. He didn't do that until the very end. And he should have given Kyle Rittenhouse some credit for cleaning that graffiti, credit for helping people medically, because he did do those things. He focused too much on making him look like a vigilante, making him look completely intentional. And he should have also focused on some of this was reckless. No matter what you think, you should not have a 17-year-old carrying an AR-15 and using it the way he did. So I think he lost that case.
Interesting. Now, Anjanette, where does Kyle Rittenhouse go from here?
Well, you know, it's really interesting, Brian. He testified during the trial that he's currently studying nursing, and we had known before that he was a police cadet at the Grays Lake Police Department. We don't know if he's hoping to maybe go into law enforcement now that he's been acquitted. We just don't know, but he was studying nursing during the trial, so we're waiting to hear more from him and his family spokesperson about what happens with him next. Right now, I assure you, he is breathing a huge sigh of relief.
Absolutely. Thank you for that reporting there, Anjanette. We knew you were live inside the court. Could only get that perspective from your great investigation and great work there. Thank you very much. Still ahead on Law and Crime Daily, former Trump advisor Steve Bannon pleads not guilty to the criminal contempt charges in the January 6th investigation. But first, the defense makes another mistrial motion in the death of Ahmaud Arbery trial. After the break, we hear from both sides. It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight.
We are going to make sure that we find justice in this case.
The three men charged will now stand trial.
I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
Well, you're a passerby coming through?
Nah, not necessarily.
That's my son that shot him. I was in the back of the truck.
Starting October 18th, watch live gavel-to-gavel coverage on the Law and Crime Network. Welcome back to Law and Crime Daily. The defendants rest their cases in the death of Ahmaud Arbery trial out of Glynn County, Georgia. That's where Travis McMichael and his father, Gregory McMichael, along with their neighbor, William Roddy Bryan, are on trial in the death of 25-year-old Arbery. All three men face life in prison if convicted on charges of malice murder, felony murder, and aggravated assault. Arbery's death captured the nation's attention after a video of the February 2020 shooting went viral. Gregory and Travis McMichael tailed Arbery in a pickup truck as he went for a run near his home. He was unarmed at the time. Travis McMichael eventually shot and killed him, claiming self-defense and citizen arrest, a law that has since been repealed and replaced. On Thursday, the lawyers for all three defendants rested their cases. Meanwhile, hundreds of black pastors descended on Brunswick, Georgia on Thursday to show support for Arbery's family. This came 1 week after defense attorney Kevin Goff called for, quote, no more black pastors in the courtroom, after he saw Reverend Al Sharpton sitting with Arbery's family.
Everybody saying, we coming. It ain't gonna be just 100. We gonna double that number. And I think this is the largest congregation of pastors that I have seen at a trial in my life. So give yourselves a round of applause. There is a God that sits high, but he looks down low. And Ahmaud might have looked like a suspect to you, but he's a child of God. And God promises if we stand up for the least of these, he rises us up. And that's why we are in Brunswick today. Because we represent a God that'll make a way out of no way. And no lawyer can lock us out. Because wherever you are, God is already there.
On Friday, defense attorney Kevin Goff responded to that rally, calling for a mistrial in the case. The prosecution countered, calling Goff's actions calculated. In the end, the judge denied the motion for a mistrial.
Several well-known, nationally revered figures in our country, speaking literally at the front door, I would guess 5 to 8 feet, probably 7 to 8 feet, beyond the front door to this courthouse. I stand on the argument that was presented. I would ask the court to grant a mistrial of this case based on the inherent prejudice to Mr. Bryant.
Mr. Goff is a brilliant lawyer. These briefs that he has filed are detailed, and he has filed a ton of pretrial briefs that the state has had to respond to. He is very, very smart. He is very, very calculating, and he's a good lawyer. Because on November 12th, he stood up in this courtroom, knowing full well he was on television, and made comments about Al Sharpton and then black pastors and Colonel Sanders, all knowing full well it was being broadcast on television. That was not ineffective assistance of counsel by any stretch of the imagination. That was strategic. He got the response he wanted because he has filed a motion a day based on a continued drumbeat of, well, see, people are coming and people are responding, but they're responding to what he did. They're responding to what he strategically, knowingly, intelligently did so that there would be a response so that he could then complain of it.
Back to break down the Arbery trial is defense attorney Kesia Early and Terry Austin. Terry, yet another mistrial motion by Kevin Goff. Was this stronger than the others? And what do you think the plan of all of these motions are?
You know, I think the prosecution was exactly right there. We know Goff is grandstanding. He's making a motion a day. He joked with the judge about that. It's no joking matter. And the fact that he compared this to a modern day lynching, he is absolutely biased as far as this case is concerned. And if he really wanted a motion for a mistrial, he could have focused on the prosecution's question about the death penalty to one of the witnesses. That question was inappropriate, and that could have been a grounds for a mistrial. So I think focusing every day on this other issue is ineffective.
Now, Casey, a Friday is a day of motions. One that stuck out was a citizen's arrest charge, in that a defendant cannot act on the mere words of another alone. How does that affect the case?
Well, first, you have to have reasonable suspicion. You just can't make this citizen's arrest without knowing or articulating whether a crime has been committed, in the process of being committed, or has been committed. So you can't utilize or rely on what the court didn't want to say was hearsay evidence, or someone told me that someone did this. So the court was focusing on whether or not the three defendants in this case had sufficient information other than this person or this neighbor told me that. And it's clear that they did not. And in this case, Mr. Goff is throwing a Hail Mary because he sees that the prosecution has overwhelming evidence to secure a conviction. So obviously, what was his move? To try to get that plea deal, and it was rejected.
Yeah, it's interesting to see how it's all playing out as we inch closer and closer to closing arguments in this case. Thank you both for your input. Coming up on Law and Crime Daily, the federal case of socialite GHISLAINE Maxwell looms as a lengthy jury selection process is underway. Plus, former Trump aide Steve Bannon appears in federal court on charges of contempt of Congress. But will Trump's claim of executive privilege be enough? Our legal analysts break it down after this. Welcome back to Law and Crime Daily. Former Trump aide Stephen Bannon pleads not guilty to contempt of Congress in connection to the January 6 investigation. On Thursday, Bannon appeared before a federal judge just days after turning himself over to the FBI. Bannon faces contempt of Congress charges after he defied subpoenas to appear in front of the so-called January 6 committee and refused to turn over records leading up to the insurrection on the U.S. Capitol. On Thursday, Bannon's team said they plan to move through the criminal case slowly, citing complex constitutional issues at play. The prosecution countered, saying it's a simple case that can be moved through quickly. Meanwhile, former President Trump maintains both he and Bannon do not have to release their January 6 records based on executive privilege. Last week, a federal court temporarily sided with Trump on this issue, keeping his records sealed for now. Oral arguments in that trial are set to begin on November 30th. Let's bring back defense attorney Kesia Early and co-host Terry Austin. Terry, the defense says this is complicated. The prosecution says it's a straightforward case. What do you think?
Brian, it's a straightforward case. This is a simple discovery matter. You either appear for the subpoena and produce the documents or you don't. It is not complicated. What the defense is trying to say here is that there are constitutional issues at play and that Trump's former lawsuit has something to do with this case, and the two are not related to each other. And the defense is also saying that they want to identify their witnesses. Well, discovery doesn't have anything to do with the witnesses. They can do that later down the line. And Judge Nichols just wants the case to move forward. He's already indicated that. And I think that's exactly what we're going to see at some point in time, if not right now.
Yes, sooner rather than later, but we'll see when that comes around. Casey, what do you think of Bannon's defense, and how do you think it will play out at the end of the day?
Oh, that's a weak defense. If there's some constitutional issues or privilege issues, you show up, you respond to that subpoena, you show up with counsel, allow counsel to raise the proper objections, preserve it for the court, and then make the appropriate ruling. But you just don't disregard a subpoena. If you do, then you have to reap the consequences. I had a case before where I subpoenaed a law enforcement officer, and this was a virtual depo, and he refused to turn on his camera. So I abruptly ended the deposition. I filed my appropriate motion and my rule to show cause. And a host of officers in his defense showed up for support. But bottom line, the judge made its ruling. You answer to that subpoena and you follow the law. So no one is above the law.
Seems like a procedural issue that Bannon's going to have a similar issue with. Thank you for that insight on that story. When we come back, GHISLAINE Maxwell is headed to federal court. We look ahead to the former socialite's trial and examine this week's jury selection process. Welcome back to Law and Crime Daily. A lengthy jury selection is expected in the trial of socialite GHISLAINE Maxwell, accused of facilitating and participating in sex crimes involving minors. This week, a U.S. federal judge began screening more than 200 potential jurors in the case. 59-year-old Maxwell is charged with 6 felonies, including conspiracy to entice minors to engage in illegal sex acts and transportation of a minor to engage in an illegal sex act. These charges stem from a relationship with longtime companion Jeffrey Epstein, who was arrested on federal charges of sex trafficking in 2019. Federal prosecutors say Maxwell helped Epstein groom girls as young as 14 years old for sexual abuse and sometimes participated in the abuse. Maxwell pled guilty to all charges and has been held without bond in a Brooklyn jail. The trial is set to begin on November 29th. Law and Crime's Adam Klasfeld will be at the courthouse with the daily updates. Casey, just a quick correction. She's pled not guilty to those charges. Yes. The judge is questioning 200 prospective jurors to get 50 qualified jurors to then get 12 jurors and 6 alternates. After seeing the Rittenhouse and McMichael and Bryan trial, how do you think selection here will play out?
Well, obviously, the facts are totally different. However, she is a socialite, so this is a high-profile case. The question now becomes whether these allegations, the prosecution has sufficient evidence to prove these allegations. Was she just a socialite that was just doing or as instructed by Mr. Epstein? A dead man can't talk, so it's her word against his. Or did she know more? So the prosecution is going to have to tie those loose ends together in order to prove beyond a reasonable doubt that she was an active participant and knew more than what she's saying.
Makes a lot of sense in that aspect. Terry, what do you think are the difficulties of jury selection in this type of case against GHISLAINE Maxwell?
Well, like Casey has said, this is a very high-profile case. Chances are all of the potential jurors know about the case, and they're going to have their biases one way or the other. They're going to have very polarizing issues in this case. There are a lot of people who are in support of the Me Too movement. They're in support of the Time's Up movement, and they have their opinions about that. And when they go through that voir dire, they're going to have to ask very detailed questions. I expect that the questionnaire is going to have specific questions about what do they know about the case, how are their feelings about the Me Too movement, have they ever been involved in this type of case personally? And they've probably all heard about the Weinstein and Bill Cosby cases, and that's something, too, that I think is going to affect the jury selection. And so it's going to take time, and you're going to need people who have time to deal with this long trial.
Absolutely, and thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.